Yashmin, hi. It's really
Hi,
good
how
to
are
have you
you?
here.
Yes, very good to meet you on a Friday as well. The sun's
Yeah,
out, they're all good.
yeah, the sun is out. I hope it stays out for longer this summer. It's well needed with
Well,
everything that it.
we probably had our 3 weeks of sun, and then that's it now
Oh,
for the rest of
don't
the
say
summer.
that. With everything happening in our industry, we need at least the sun.
We need some happiness.
So, Yasmin, tell us a little bit more about you and how you entered block management. And just a little bit of background, really, for our
Wow.
guests.
Okay, so I entered management like probably everybody else by accident. So what did I
Typical.
do? So I went to I did the normal route, went to university, qualified, did my training contract. And I think it was when I started doing my training contract that I started to develop the interest in leasehold just generally. Um, so the practitioner that I did my training contract with to qualify did leasehold, and I actually did as a trainee my first ever freehold purchase of a house, 33 Portland Street. In London. So I remember that very distinctly.
Yeah.
And I also remember some service charge cases, and that's where I came across Justin Bates. So we both rocked up one day, I as a trainee, and
Hmm.
Justin obviously as counsel on the other side of me, and we both met at the Lands Tribunal and kind of hit it off from there. We
Yeah.
kept in touch, and now we're the best of mates. So yeah, and we're both
Amazing.
in the same industry. So yeah, that's how I got into leasehold, and then from there. It's just been a journey. Leasehold is so broad, so vast,
Yes.
and every day is a different story, a different, you know, disaster sometimes. Um,
Yes.
and no day I think is the same, which is what's exciting about the industry that we're in, I guess. Well,
Yeah,
it is for me.
absolutely. Absolutely. And what is kind of typical day like?
Yeah, my roles is slightly different now because obviously I don't do as much. I do. I keep my hand in, the legal
Mm,
cases and all of that kind of stuff. But equally, the other hat I wear is managing partner of JPC. So
yeah.
I have to split my time between managing the business, managing the people, as well as managing, the clients, the caseload, and all of that kind of stuff. So, I think probably what I do on a day-to-day basis in terms of the legals is, having calls with clients, talking about strategy, talking about the best way to go about
Yeah.
things, and being off assistant to property managers, just so they know that they can pick up the call, that they can pick up the phone. Can I ask you a question? Can I just
Yeah.
run something past you? Because that's really important in our industry, and it's actually quite interesting. Our industry, we're a family. I know that sounds really weird to talk about us or the industry as a family, but that's what it feels like. You can reach out to people and they
Yeah,
can.
it's true. Yeah, absolutely. So JPC and you are guys based in London.
Correct. Yeah, we've got two offices, one in North London and the other one in South Kensington.
Amazing. And what type of clients do you usually work with? Property managers, mainly leaseholders?
The whole
Um,
spectrum, really.
yeah.
So we've got landlords that aren't lessee owned. We've got freeholds that have been purchased by leaseholders, RMCs, management companies, right to manage companies, leaseholders. So what I've always tried to do through my career is keep a balanced
Mhm.
caseload. So acting for landlords, but equally acting for leaseholders, because I think it's important when you're providing advice that you're able to understand the different arguments from different sides. And then property managers, but are basically the people that I talk to on a day-to-day basis, really.
JPC is covering really broad spectrum of the industry. So I will put your details, and if anyone is interested to see what you guys do, they can find you and also speak to you. Um, what where do most disputes and misunderstandings you kind of see in cases that you're dealing with?
um Most of the, I mean, leasehold, yes, we've got the lease, which is the contract. But ultimately, leasehold is about people living together in a building, and they've got different backgrounds, they've got different priorities, they've got different things. So a lot of the problems or issues that we see are just where those competing interests are clashing. So
Yeah.
yes, I mean, yes, you've got the lease, yes, we've got the legislation, but a lot of these things possibly can be talked out, through mediation, through using practical common sense. And I know
Mm,
that's not a lawyer kind of answer, but sometimes the lease, I mean, ideally, the lease should contain all of the answers. But sometimes, as you know from experience, it doesn't,
mhm.
or it's silent,
Yeah.
or it's really confusing. So sometimes, occasionally, you have to put the lease aside and just use practical sense. Other times, you have to look at the lease, look at the legislation, and follow it to the letter, because you can get into trouble. So I think
Yeah.
there's also the it's a balance.
I I enjoy reading leases, but very often I'm lost, and the more I read it, I either find the answers or I get even, more like, oh my
More or
God,
less.
what does that mean? And it I I think as us as property managers, we are expected to kind of be able to read and interpret leases, but I don't really think it's our job, really.
I don't know how property managers do what they do. It blows my mind, in terms of what you're expected to do, what you impose on yourself in terms of expectations, but what generally is expected of you, because you're expected to be the lawyer, you're expected to be the
Yes.
accountant, you're expected to be the fire expert, the plumber, the electrician, the person that gets rid of pigeons. It's
Yeah.
just so wide and varied in terms of property managers' roles. And I, sometimes we find, most of the property managers don't know quite where that line is drawn, in terms of saying no to clients or no to the people that are calling them. Because obviously,
Yeah.
that's where you guys are caught as property managers. So I don't know. I wouldn't want to do your job.
I
Sorry.
thank you. I definitely learned over the years that that is something that I don't I'm not confident most of the times to answer and to take part of, yeah, that's what the lease says. And many times directors will be, but that's what the lease says. And I'm like, okay, but again, I'm not going to confirm because it's really not. I like you said, that can get me into trouble if that's not the case. And for me, I often say I'm not legally trained to do
Yeah.
that, and I would like to involve a law firm that will read and interpret the leases for us, and even draft letters if necessary to whichever party is necessary, because that's why you guys there.
Yeah, exactly.
The
But even the leases, I mean, they're so bad. Most of the time, they're so badly drafted. When you've been in
old
the
ones,
Yeah.
yeah.
But when you've been in the industry for as long as I have, you get scared when someone sends you a lease because you might have drafted it yourself,
Mm,
when you were a trainee or 15 years ago. And then you've only got yourself to blame. But yeah, solicitors, unfortunately, when they're drafting leases, they just seem to kind of use the same precedent. If it works for one block, they kind of think that it works for another. And that's why we're getting ourselves into quite a pickle, because we've got so outdated leases. But equally, because leases, some leases were granted for 99 years, some for 125, and some for 999 years, those
yeah,
leases don't kind of fit with modern practice, in terms of how
yeah.
we're living now. So, for example, wooden flooring, that's a massive thing that
Mm,
most property managers have to deal with, because most leases will say carpet and underlay. You might have a random lease which says or other suitable, um, sound deadening material.
yeah.
Um, and then when you come across that, you think, yay, we've got, some solicitor thought about, how they drafted the lease at that point. But yeah,
But it's fairly like moving, year by year, you kind of adapt to what is reasonable, and people prefer now to have wooden floors than
Correct.
carpets. Have you ever read a lease that do you recall reading a lease that you actually drafted? Because you mentioned it earlier.
No, no, no. I do get scared though, because it is one of the things. The only reason why I mentioned it is the other day I asked a client. A client reached out and they said, I don't know, they had an issue, and I said, obviously, I can't do anything without reading the lease.
Yeah.
And they sent me over a lease that I drafted when I was a trainee. So yeah, it was quite funny.
Yeah, I never thought about it. That actually could happen, but here it is. And in terms of leases, because you often, and I often have heard from leaseholders, well, can we change that? How do you change lease? Like, how do you change? How do you do that? It's not an easy process. And is it individual? Is it us, the whole building and everyone? And sometimes leases can be also different with, you have 10 flats, you have 10 flats and 5 of them have different leases. Because, in the LP1 forms, you have all leases in the building with the
Correct.
same terms. And like, tell me a little bit more about this, because I think it's interesting topic.
It's mind blowing, isn't it? So yeah, I mean, I've come across lots of developments where
Mhm.
leases are not the same. So the worst development I came across, I think there was 25 flats in the block,
Mhm.
and literally we had 15 forms of different lease.
Yeah.
So, but then until someone did a full scale review of those leases, everybody
Oh,
was.
you mean the property manager? Because usually that's us
Yeah,
when
so
we take
property
over.
manager, yeah, but in that situation, obviously, it came down to us, which is
Yeah.
why we identified that there was 15
Yeah.
different forms of lease within that development. Now, in theory, most leases, most of the time in the leases, you will have a covenant by the landlord to say that they will grant leases in the block on the same terms.
Terms, yeah.
What generally tends to happen is either when the lease is originally being granted by the developer, so the first lease when it was the first grant, there'll be conversations when the flat was being sold. Oh, can we tweak this, or we want something else different, or whatever. So that could be one of the reasons for changing, for the leases being different at the outset. Or you could have a situation where either licenses to alter have been
Yeah.
done, and as a result of that, the leases need to be varied, or the leaseholder has an issue, or a lender has an issue, and they've approached the landlord to enter into a deed of variation. So that could be another reason why some of the leases are different.
Yeah.
But as a property manager, it's a complete nightmare,
It
because
is.
obviously if you've got different forms of leases, you've got
Mm-hmm.
different tiers or forms of management. And that's a complete nightmare when you're trying to deal with service charges. Um, and then dig further, some leases, I've seen developments where some leases have got the ability for the landlord or the management company to collect a reserve fund, and other leases don't have that obligation.
Yeah.
So it's a nightmare. So sorry, going back to
And
your
it and it
original
and it
question.
yeah, yeah.
What?
Please.
Yeah, sorry, what were you going to say?
I was going to say that when you mentioned that some leases don't have the provision for reserve fund,
Yeah.
but the directors agree to have that reserve fund, and then the leaseholder comes in, whether new or still in the building, and they're like, but we don't have a reserve fund. I'm not paying for that, and
Correct.
it just goes into 50 emails of correspondence and calls. So yeah.
And that's a nightmare. That's an absolute nightmare to try and unpick, because obviously if you've been collecting reserve funds where the lease doesn't entitle you to, then technically, the whole of that money is due back,
Yeah.
plus interest,
Yeah.
arguably. And then what you do with the others, that have been paying the reserve fund. And if one leaseholder's found out about it, but the others haven't, obviously it needs to be rectified. It's a whole can
And
of
there's always one person in the block that will pay.
yeah. It's like this. Every block has one difficult director most of the time,
Or
and
leaseholder.
usually they're ex-solicitors or retired solicitors because they've got lots of time on their hands. Not wishing to do my industry a disservice, obviously.
No, you're going to be in the freehold when you retire, so you're not going to pick up on any of that.
Exactly. Sorry, I don't think I answered your question. So
Right back.
in terms of how you go about changing leases, it is difficult and it's a long
Yeah.
process. So there's two ways generally to change leases.
Mhm.
One way is to get agreement by all of the parties. So if you've got a tripartite lease, so a lease between landlord, management company, and leaseholder, all of those parties would need to agree to the variation, but
Mhm.
also any lenders. So if the leaseholder's got a lender or a mortgage company, or the freeholder's got a lender, they would also have to agree to the variation. Now, can you imagine in a block of 40 or even in a block of 6 trying to get
Yep.
every single leaseholder to agree to the same variation? And sometimes the variations don't favour all of the leaseholders. It's quite difficult.
Yeah.
Um,
It's
so,
challenging.
yes, so it can be a challenge. The other alternative is to make an application through the first year tribunal
Mhm.
to obtain a variation order. Now, there's different grounds on which you can make a variation order. I think it's Section 35, which allows you to make an application if the lease is defective in any way.
Mhm.
Now, that's quite a difficult test to apply because just because one of the parties wants something included, like a reserve fund included,
Yeah.
doesn't necessarily mean that the lease is defective because it still works with that reserve fund. Where those applications are designed for is, for example, if the lease has been granted and there's no obligation on any party to maintain, say, the roof or the foundations, then
Yeah.
arguably the lease is defective. Um, so you've got those grounds. You've also got another ground where you can make an application by majority, it's called.
Mhm.
So if you've got I think depending on numbers, if it's a block of more than 9 flats, then 75% of all the parties would have to agree to the variation, with not less than 10% objecting. So if you've got those numbers, then you can make an application to the FTT. But again, it's a long, protracted process
Yeah.
because, as everybody knows, with FTT proceedings, it's litigation, right? And you're opening yourself up to any of the leaseholders wanting to challenge the proposed variation.
Yeah.
So yeah, it's quite tough,
And
and
it's
as you say, a
costly.
challenge and costly. And then you've got arguments, as with everything, who's going to pay for these costs? Is it the freehold company? Does the lease allow the freehold
Mhm.
company to be able to recharge the costs of making that application through the service charge? Or is the lease silent on legal
Yeah.
costs? Again,
Yeah.
it's another property manager's nightmare.
We often see taking on new buildings, and some
Yeah,
doesn't matter how big the building is, but we just be given one lease, and we are like, well, we need all leases. We need all leases, and that's because we've learned our lessons that we need to check all the leases.
yeah,
And so we kind of have a process now that we oversee with the handover what is in our files. If not, we just advise the directors that we will go to land registry, because obviously we can, and download all the leases and any documents that we require, and recharge the property, because we've also tried by requesting these documents directly, to the leaseholders, but many times, guess what the answer is? We don't have it. Yeah. Like how and why you don't have the lease? This is your document, the one document that you need to have, like land registry and
yeah,
lease. But I often also have found, no, I wouldn't say often, but it has happened when the lease is not available on land registry. So how do you do that? And for example, one I recall now, they were signing deed of variation because what happened is they had an extension in the building, a few flats, and everyone was signing. Just obviously, that was the service charge proportion that was changing from 1.9 to 1.12, and a couple of variations were not signed. So how that was a bit challenging, but what is the best practice here to do? Because I was going through, a lot of law firms trying to find who
Yeah.
actually did it, and then actually the person that didn't sign it passed away. So it's been, I don't know, 4 years now. We're just trying to get that resolved with inheritance, and oh, nightmare.
Sounds
Any
like a
advice?
nightmare. I'm going to leave that one with you. Yeah, no, it is a challenge. And it's amazing that when blocks are going to move between managing agents. That's just
Yes.
life. It's just
Yes.
part and parcel of property management. The one thing that surprises me, however, is when a managing agent moves or loses a block.
Hmm.
At no point have I been ever asked by a managing agent what deeds am I holding as solicitor for that block, and whether I can send them to the new managing agents, because in theory someone should be holding them, either whether it's the landlord or the managing agents, or their the solicitors for the landlord. Now, what should happen previously, what used to happen is landlords used to have their own collection. So when you complete a lease, you complete it in two
Hmm.
parts generally. The leaseholder signs their part, the landlord signs
Yeah.
their part, and then you
Hmm.
exchange the two parts. So you've got
Hmm.
the original and the counterpart. Um, Most of the time, the landlords retain their parts, or their solicitors hold them in their deeds storage system, and then they can dig them out. But obviously, with freeholds changing hands where leaseholders are buying, it's not something that's necessarily picked up. So the
Hmm.
originals can be lying in someone's deed storage system, and the
Yeah.
block is, managed by, totally different parties. It is a pain. Now, obviously, you've got the land registry, and they have scanned leases in now, so they keep electronic copies. But again,
Hmm.
it's not a full. It has flaws in the system, because sometimes the land registry don't quite scan it incorrectly, or they scan in
Yes.
not coloured plans. And obviously,
Yeah.
as everyone
Like
knows, we need
crooked.
or crooked pages, or there's pages missing. Um, so in those
And
kind of,
written in hand,
yeah.
written by hand.
or sometimes, really crucially, when you're asked a question, what does the lease say in relation to pets? So you say, okay, let's have a copy of the lease. Nobody's got it. Let's go to the land registry. You download it from the land registry, and guess what? The one page that you need, which deals with pets in the regulations section, is
No.
missing. And you've got a note from the land registry to say this page is missing. No, really. So yeah, in those kind of situations, what you would probably have to do is review,
Yeah.
a cross section of the leases within the block, in terms of that page, and if they are all on a similar form, I mean, you would probably have to assume that that lease with the missing page was on a similar form, if that makes sense.
Yeah.
Obviously, it needs to be rectified. So to put that lease in play, to put that page back in, you probably need a deed of rectification to replace that page, or or the
Oh, I
plan
see.
that's missing, or
Hmm.
something like that. If there's a lease that's missing and you're doing a lease extension, it may be that if you're doing a lease extension, you can tie it into that document. Either you have a fresh lease rather than a lease by reference. Does that make sense?
Yeah. Yeah, yeah, it does. I didn't, I've never come across that. But, and it's also interesting that I've seen in a lot of conversions how basement flats, because they have their entrance and they wouldn't have
Yeah.
um, use of the common area, they will vary the lease because they don't want to pay for electricity. But
Right.
in some cases, I've seen where they are responsible to pay for the intercom, which I'm like, but there is no
Intercom.
doorbell for them. So yeah, I've seen that, which is made me think of like why. And I've seen it on few occasions. They don't pay for anything that is internal,
Yeah.
but just the intercom, which was interesting. And the roof, when the top floor, the top floor flat buys the roof, they are responsible for the roof and the maintenance of the roof. And then if there is like a little, so we currently have this building where there are a couple of small areas, like roof areas, that actually there are two freeholders. It's a small building of four, and the freeholder is also contributing a proportion on top of the split between four, and we're currently going through this, and it was the first time I've ever seen something like that. So I'm not sure. And if you calculate the percentages, they're actually not adding up. So yeah, it's something that Karina and I are working on, that trying to
Oh my word.
rectify.
Okay, so
They're
that
like
sounds
5 schedules.
sounds super complicated. But I mean, again, if the service charges shouldn't add up to more than 100%. So if that is the case, then it may be, if you can't get agreement from everybody to vary the leases, it may be something that goes to the first tier tribunal for a determination or a
Yeah.
variation order, because obviously the landlord shouldn't be allowed to collect more than 100%. Equally, if the service charge proportions in blocks are less than 100%, then obviously, again,
Okay.
we need to get that corrected.
Yeah.
But again, I don't know whether property managers do this when they first get a block on board, whether whether they do check as part of their DD.
Yeah,
Whether
we do,
service
because
charges add up to
yeah.
100%.
Yeah. So we do, and I'm pretty sure a lot of property managers do, because if you don't do it, and most of the times at the beginning, when I started taking over new blocks, I wouldn't necessarily check, because I'm like, yeah, surely they've done it
They've done
correct.
it themselves.
Well,
Famous last words, that is.
exactly. That proved me wrong, obviously. And ever since, it is something like, it's one of the most important things. We need to get all leases. We need to make sure that everyone's percentage is there, and we can onboard the property correctly on our software. We all work now with softwares, and you have to have these onboarding. The onboarding process is really important. You need to be to the to the last number, and whatever you're doing, you've got to be correct, because otherwise you may have to delete the whole block and start again, especially when
Yeah.
it comes to financials. And because you're serving demands, they have to be correct. And someone says, but my percentage is different, and if it's different from what they've been charged previously, we will explain, this is your lease and this is what it says.
Right.
And sometimes they don't agree, but I'm like, this is your lease. Have you seen your lease? Have you read your lease? So it's a little bit of educational process here, but I think it's important. And if there are any property managers listening there that don't do that, please do it. Because also, if you think about it, if you're passing over, we don't manage buildings forever. Things sometimes go wrong. We pass them on to someone else, and that's how it's been. It will be. And so the leaseholders effectively paying twice and 3 times and 4 times sometimes for these documents, and it's not fair. It's let's just do this properly and hand it over, and read leases. That's the least we can do. And it's also tricky sometimes when their percentage is not listed, it's not stated. So again,
Yeah.
we just
We've
call
seen
you guys.
we've seen the whole spectrum. So sometimes we've seen leases where there's a blank, so it's this flat has to pay X%, and that percent is bracketed.
Reasonable costs.
Yeah. Or sometimes, what else have we seen? So we've seen that. We've seen percentages not adding up to
No.
100%. We've seen some of the leases in a block, the same block. We've got some leases which say the land, a reasonable, fair and reasonable percentage of the expenditure of the year, whereas
Yeah.
others will say it's X%, and it's just trying to marry all of that up to make it work, if that makes
Yeah, yeah. And
sense. Yeah.
schedules in budgets are so important, and they come from also the leases and what and who is paying for. Often leaseholders argue with some of the costs, but dear leaseholders, we're going with the lease. That's our Bible, right?
Yeah, That's right. And this is one of the things. So it's amazing how many property managers don't use a particular application at the FTT. So if you're not clear on whether a service charge is payable under the lease or is due under the lease,
Mm-hmm.
there's an application that you can make to the first tier tribunal. Section 27 3A, I think it is.
Mm-hmm.
And basically, what you do is you literally ask the tribunal to make a decision. So you send through a copy of the lease, and you
Mm-hmm.
send through a copy of or a description of what you would like to charge, and then you just ask the tribunal to make a determination on whether the lease allows you to put this cost through. So
Okay.
it's an application which is so underused by property managers, landlords, right to manage companies.
Yeah, I didn't
Um,
know about it.
yeah. So yeah, this is what I'm saying. It's such an underused application, and
Yeah.
it's so simple. You can do it on paper. You don't necessarily need a hearing, and you can just get a paper determination. It's super useful because you can determine when it's payable, or you can ask the
Yeah.
tribunal to determine what's payable, when it's payable, and by whom it's payable.
That also applies for financial year, service charge year. They can determine because sometimes it's also not on the
It's
lease
not clear.
before.
Yeah. So
Yeah.
you get that determined by the tribunal. So as I say, it's a section 27 3A, or it could be A3. I think it's section 27.
And the client can be recharged for that, right?
Again, it depends on what the lease says, but it should be a really simple application. You can do it in
Right.
advance. So before, if you think a block is going to challenge a particular cost through if you
Mm-hmm.
put something through the service charge, or you're not clear on your reading or your interpretation of the lease, you should whack it
Yeah.
in this application.
Okay, and it's a small cost, I guess, to pay, so it wouldn't be harming
No,
anyone's
I don't think
pocket.
so. I think it's the tribunal fee. So I don't know what that is,
Yeah.
100, £200 for the tribunal
Okay.
application fee. Possibly, I don't know. You would need to check the
Yeah.
tribunal fees. But yeah, it's something that property managers should use a lot more, I think.
I honestly never heard of it, but I would definitely will definitely make a note and use it because I think it's more with the old buildings. I remember when I started in block management a few years ago, there were we in the company I worked for, we had these folders with leases, and they were so beautifully done with like red ribbons and like
Okay.
some
Yeah.
lace on the side, or like I've never seen anything like that before. Not that in my country, in Bulgaria, we don't have such thing where as leasehold and freehold. And I remember my deed is just well, it was before like A4 page. That was it. But here there are 100 pages. But
Was it super simple though, the system, or is it
yeah,
still
yeah,
you're
just
dealing with people?
a little drawing at the back of the demise property, and um you own this property on this address. It's common hold, right? So you don't you own the flat, you own the flat, and that's it. There is no landlord, there is no there is no leasehold freehold, and it's
So
kind
it's
of
not a common
simple. But
hold.
now it's actually changing because we are having more developments that are built by organizations or developers or whoever party, and they have within the deed that you are paying X amount for maintenance each month, but that is already with it agreed, so you can't challenge them because this is why you buying the flat when in this development with that maintenance plan already, whether you have the concierge, the parking, the cleaners,
Right.
um, but it's still kind of more simple than what it is here. And it kind of varies with the size of the flat, of course,
Yeah.
but it's kind of at the very beginning. Whether here, um, it we still receive a lot of calls from leaseholders who are first time buyers, or they're just moving to the country, and for them it's like they don't know what they're buying into, and they don't know how property management works. So sometimes I put myself in their shoes, and I try to give them as much as time as I can to explain what it is, and yeah, and what they're paying for. But anyway, challenging leases. So it is changing here as well. They're becoming more clear, which is great because we can. I want to see the date. I want to see the percentage. I want to see what they're responsible for, and I want to see that clarity so I can move on and do my job. Yes, of course, there will be always someone challenging something, so that's where you guys come in.
Yeah, well, it will keep me in a job until I retire, hopefully, but let's see.
Sure, I don't think AI will take your job yet.
Well, it's coming, isn't it? AI is coming to take us all, so let's see.
I think it's helping, but it won't take your job away or anyone's job
No, you
yet.
still need someone to. I mean, they are getting quite clever in terms of interpreting leases and things, but again, it's the hallucinations that it produces, and a lot of this, we're a people industry. It's
Mhm.
you're still dealing with humans. You're still having, the neighbour disputes effectively sometimes between neighbours, maybe
Sometimes, all
all
the
the time,
time,
all the time. Sorry. On
all
the
the time.
field, in the
Yeah,
field, it's neighbour
yeah.
disputes. Someone's put the washing machine on at 3 o'clock in the morning, or there's a leak,
Mm,
or AI can't necessarily kind of
no.
deal with the people aspect or the human aspect.
No.
So I think property management is still very much a people business. But
Absolutely. And we can just use it to, you know, in terms of admin, really.
yeah,
That's how I see it. We do a lot of that on the background. We're still running a lot of, tests, and the data is still not clear for the reasons that it's difficult to get leaseholders to use AI Property Manager to ask questions, but also they need training, right? So you need to feed a lot of information. I need to prompt them properly, and when you ask questions, they should be clear, and that's where the help comes in. And there are a lot of banks and a lot of organizations that actually are using these bots on the background when you enter, their website and chat with us. And kind of it's the same with property management, but it's something that people are not used to, like leaseholders are not used to, because they're used to calling you or coming to your office. A lot of us now don't have an office. We work remotely. So yeah, it's becoming like a lot of admin orientated job. I don't go out as much as I used to on site visits and clients meetings because everything is online. But again, it's the admin side of it, and the like you mentioned, the neighborly disputes that are kind of majority of what we're dealing with, really.
yeah.
So it's people's management more than block management.
It is. And whether that's a leasehold system or whether that's a common hold system, it's still going to be people because it's people at the heart of it. And
Absolutely.
people living together in a block is not easy.
No, but I think when you're buying a flat, you're kind of buying into
That mindset.
living. Yeah,
Yeah.
and
Still
you
living.
you are sharing that
Yeah.
space with others. It's kind of like I often say to people, when you went to uni, didn't you live with, flatmates, and you were sharing? Probably the priorities are obviously they were not priorities probably from back there, but still you are sharing that space. And now, yes, you can close the door and it's just your own, but you still enjoy, whether it's a garden, whether it's I recently went to a building, and they have beautiful outside, like outdoor space,
Yeah.
and no one is using it because they don't really know each other, and it's only like 40 units building. They don't know each other, they don't care about it, and it's also the financial side of it, because it's like, why are we paying for a gardener when we don't have, when we're not using it? And I'm like, well, why don't you organize like at least an annual meeting in the summer and just have like a neighbors drinks, and they're like, oh, no one's interested. So yeah, we try to
Wow. Okay.
yeah, we
I
try
think
to
we
give.
need to go to that block. We need to have PIMS parties, PIMS
Oh,
o'clock.
Yeah,
We need
I
to
think
do
some
like
of
barbecues.
yeah, I definitely I've seen some of the bigger developments in the country that I manage that property managers
Yeah, yeah,
initiate that for Christmas, and I think it's lovely, or
yeah,
like in the summer, and I think it's lovely. So it has to be done. It's one way to interact with your neighbors, to kind of know them, to say hello in the morning or evening when you're coming back, and it's just being human and being nice to others, right?
yeah. Which is yeah, and it goes back. Then it comes back to communal living, humans living together. And until we're not living communally, we're always
Mm,
going to have kind of issues. So it doesn't matter on the legal structure. That's
yeah.
really what it comes down to, I think.
Yeah. But yeah, just going back to leases is something that it it's very challenging on our side as property managers,
Yeah,
because we're expected to interpret the lease as a solicitor would, and when we don't have all the information, because it's not clear, it is difficult. So I have approached you know law firms in order to help us with that, to determine these, because
yeah.
I do say to the client, you will have to pay for it, because we don't know. And I stopped feeling bad as if like, or incompetent. Because that's how I felt at the beginning. Oh, I should know this. Well,
I
not
don't.
really.
You shouldn't.
Yeah. I
It's
didn't
like you're not
recognize.
an electrician, you're not a plumber. Property managers are not lift specialists. You subcontract that out to the best people that know what they're doing. So why would you do that with legal?
Yeah. Well, do you think that there are any like clauses within the lease that are overlooked, and or like common mistakes that are made, and obviously it's
Yeah.
accelerate.
I guess it depends on the block, it depends on the issue. I mean, the ones that we're normally asked to look at, we're normally asked in relation to, reviewing or interpreting a lease are who's responsible for the roof, who's responsible for the foundations, who's responsible for maintaining things. Is the leaseholder responsible for their front door? Is the leaseholder, or is it the landlord who has control of the windows?
Yes.
So
True.
those are the kind of common issues that we come across. But then again, it's like, do I need consent for a pet? Can I put a satellite dish? I mean, it's not so much of an issue now, but satellite dishes, and more now, it's reviewing the leases to see whether with the EV charges and the EV car parking charges and the car charges, can we put those costs through
Oh yeah.
who's responsible for the communal electricity, or can I just plug my car in and that's it? So I mean, those are things that we're dealing with now, because obviously the leases, like we were talking about wooden floorings, when these leases were granted, nobody really had laminate floorings, they didn't have hard
No.
floorings.
Yeah.
Equally, no, things.
People had carpets in the toilets, in the bathroom.
Yeah, exactly. Carpet and underlay.
Sorry.
um, but yeah,
And avocado.
when these
And
leases,
the avocado colored bathroom. Oh, these were hilarious.
I mean, you've obviously
Sorry.
done lots of site inspections.
I have, yes, I have seen few.
But similarly, like I said, when the leases were granted, nobody had thought of EV charging,
No,
where those
no.
points have got to be, how you connect, to the communal electricity, and all of that kind of stuff. And the leases don't deal with it, so it's a question of, do we need deeds of variations? Do we need to go to the tribunal to get it interpreted, using section 27(3)(a) or whatever I just said? And yeah, those are the issues that we're dealing with at the moment.
But these issues in 20 years, if you
Will be completely different.
will be different, yeah. Because there will be, I don't know, some helipads on every building. I
Well,
don't know.
we've got buildings with helipads on them.
Yeah, but like majority, or they will have some sort of something to do with the air, taxis, or I don't know, Fifth Element is coming, hey?
Yeah, exactly. But that's the joke, because the leases are being granted for 999 years, say, or even 125 years. The question is, the building is not going to be standing in 999 years. Great. It's great having a 999-year lease or a 990-year lease, which is proposed by, with these reforms and stuff. But the building, really, not with the state of construction as it is at the moment.
You guys are dealing with a lot of RTMs, and it, would you take me a little bit through that process, and because it's happening more and more, and people are taking control of their buildings.
Yeah. So right to manage is very different from the freehold purchase. It's a no fault right, as everybody knows, and but because there's no capital payment being made, it can be quite contentious, because the landlord doesn't necessarily want to give up their management or the commissions that they're taking on insurance, and all of those nice bits of management. So you have to be careful with the process. It's still procedural, even though it's no fault. It's still a prescribed procedure that you have to go through. Obviously, because of the market, the leasehold sector, the leasehold industry at the moment, what we're tending to find is, because everything's up in the air, with the calculations and marriage value, will it be abolished? Will it not be abolished? What will the new formula look like? People are kind of taking their foot off the pedal, in terms of doing the lease extensions and freehold purchases. And what they're doing instead is the right to manage. And obviously, we've had recent changes with the right to manage, where 50% it's gone up to 50% of the resi and commercial split, rather than the 25 before. Now, with right to manage, it's a great way to take over management, but you have to be aware of the landlord still staying in the background. So, for example, if leasehold, once you've gone through the right to manage process, the landlord still needs to be notified if there's an assignment in the block, or if there's an application for alterations in the block. There's different notice periods, so it could be 14 days, it could be 30 days, depending on what the leaseholder wants to do. And sometimes RTMs kind of forget that, because they think they've taken over the right to manage, and that's the end of the procedure, or the process. You don't have to interact with the landlord. Equally, if someone wants a lease extension in the block, they still have to make that application to the landlord or the freeholder, rather than the RTM company. And equally, where there's breaches in if the lease is being breached, the RTM still has an obligation to notify the landlord that the lease is in breach. So there are shortfalls. Obviously, the RTM can't forfeit, because that right stays with the landlord, because the RTM doesn't take the title effectively. And also, right to manage directors need to understand, or the right to manage company needs to understand, or to remember, that they're taking over the existing leases as they are. So if one of the frustrations is that the landlord's not collecting a reserve fund, it could be because the lease is silent. Because you take over as the right to manage, it doesn't mean that you are entitled to take over, collect a reserve fund, if the lease still remains silent. Does that make sense? So you're taking over the existing lease structure and the management obligations under the terms of the existing lease. Now, obviously, RTM companies can make an application to get the leases varied in their own rights and that kind of thing. But again, it's taking over that structure that exists. Does that make sense?
Do you recall any story that with RTM that went wrong, or
I've had so many stories. So RTMs,
tell me a funny one.
a funny one. Okay, so we had, it's not funny, it's actually quite tragic. So basically we had a freeholder that was horrible. We had leaseholders that were, super keen and eager to take over the right to manage. We took over the right to manage. That's great. It was going okay for a good period. And then what happened is, the enthusiastic group of directors that took over and saw and led the RTM
Mhm.
kind of one by one, because of their family circumstances, they kind of sold their flats and they moved out. Then we ended up with nobody that kind of wanted to be on the board. There was nobody that were filing the annual returns at Companies House. And then we ended up getting struck off. So obviously in that situation, management reverts back to the landlord.
Yeah.
We've had that where leaseholders have purchased the freehold, and they've got rid of the landlord, which is great. They've spent all the capital and all of that kind of stuff. You then get to a position where nobody wants to be a director. It then gets struck off, and then obviously the freehold reverts to the crown. So it's just like, yeah, it's sometimes it's trying to keep that board of directors. I mean, you must have had blocks where nobody wants to be a director. It's the poison
Oh
chalice.
yeah,
Yeah,
all the time. So thank you to all the directors that are still there, and some
exactly.
and some of them are amazing and really kind of get into the, although it's voluntary, it's something they do in their spare time,
Yeah,
but it's very involved. They're so involved because obviously they're the decision makers, right? It's not
correct.
it's not us. We're there to advise, to recommend, and um, give them the current legislations because obviously they don't have time. Although I must admit, I really can't keep up with the changes,
So many.
but so many.
So
But
many, and the industry's been hit by just possible disinformation,
yeah,
possible just the leasehold just being used as a political tool in some. There's good rhetoric, but actually we don't see these things being implemented, and when they are implemented it's very rushed and they don't actually come into force.
yeah,
So there's so many things that it's just all up in the air, so you can understand leaseholders'
absolutely.
frustrations.
Absolutely. Well, we are also frustrated because sometimes we are, like we said many times, we mentioned on this chat already, that we are expected to be, these people that know everything, but we don't. And that leads me to another question of what can managing agents do to protect themselves? And because anything you do and everything you do, you can you can end up being legally liable, or someone just sends you a formal complaint and they're just ready to take you to court because you've either made a mistake on mentioning not the right act or article. And what can we do to protect ourselves in situations like this?
Yeah, I mean, it comes back down to property managers knowing what their role is,
Yeah,
going back to what you've agreed with the client, and that is looking back at your management agreements. What have you agreed to do, and what have you excluded? And sometimes
yeah,
it's the exclusions that are the the more important, if that makes sense.
yeah,
So I think it comes down to property managers really knowing what you're meant to be doing under the terms of your management agreement, and what bits you've said to the client, these are outside our remit. But as property managers, you want to, because all of you have got a responsibility, Jean. You want things to be right for leaseholders, and sometimes
yeah,
that kind of plays it is your worst enemy, if that makes sense. So for property managers, it's knowing where they are. But one thing for property managers as an industry, I've always said it, I say it at every conference that I speak at, is we need to get to a position where property management is seen as a profession. I mean, we try, it's great having TPI. It's great having what was it before that? It was the IRTM
uh,
and the exams and all of that
uh,
kind of stuff.
yeah,
But still, is property management really seen as a profession that people want to enter? Um, and is it seen as a profession? Because it should be. And I think probably we as an industry need to do some more work around that to make it more attractive.
yeah. But I think the expectations of a property manager,
Yeah.
they're big. There's so many changes. There is just everything, like we're wearing so many hats, and at the end of the day, like you said, we should know what we signed for, what we agreed to, what we are responsible for, and and not be afraid to say no to, no,
No.
this is not our, it's not within the services that we've agreed. And there is either the additional charges that we all have, because we know that with the past few years, everything has have changed so much. We have the high rise costs that it's additional. We have, legal cost, and um, or any additional cost that can be outside the agreed services. And I've done that. I've done this many times when I will just go and deal with it and not charge. But at the end of the day, it's like, why am I doing? And I would like to have like at least an email or a call sometimes to say, well, thank you for dealing with that. And it's so rare. It's so rare that the stress level is high and the appreciation is almost, it's very low. Um, but
Yeah,
this is what we're trying to change, right?
but it comes back to what this, it's the PR piece about what this
Mm,
profession or what this industry is. Um, is it a profession that people want to go into? But equally, it shouldn't be a race to the bottom with
yeah.
regards to fees. Property managers should be charging what it takes to manage, but the reality is leaseholders don't want to pay that. So you can't have you can't have your cake and eat it. You either want your building to be managed and managed well and with the right professionals that are managing it, because after all, it's probably most people's biggest investment, right?
It's
Um,
people's homes, yeah.
Correct, it's people's homes, and you want the best for it, but equally that comes with a price tag. Now, there is a balance somewhere in terms of how we strike that, but I think as an industry, we need to stop this race to the bottom with management
Mhm.
fees.
That's a
Um,
great that's a great that's a great advice. There are way too many changes. I'm some days I'm scared because there's just something else that coming up and there are pages and pages to read. Um, but I think there is the change that needs to happen in terms of us as property
yeah.
manager being able to say, I don't know. It's not for me to deal with that, right?
Correct. And that's what I say to quite a lot of property managers that ask me, they'll pick up the phone, they'll send me an email to say, how do I fix this? And I say, have you spoken to
Yeah.
your directors? Because I don't think this is covered by your PI insurance.
Yeah.
I don't think this is covered by the terms of your management agreement. You need
No.
to, I would never dare to answer a question on, I
Yeah.
don't know, a boiler because I'm not qualified. I
No.
wouldn't dare to answer a question on whether the tanking is the correct form of tanking because that's a
Yeah.
surveyor's.
Yeah,
That's not my
absolutely.
job.
Yeah.
Equally, property managers need to know where to draw the line, and that's
Yeah.
something that I think managers, directors should be encouraging their property
Yeah.
managers to do more often.
And I do appreciate costs is involved,
Yeah.
but they are these different parties that are professionals in that industry and they are the ones to deal with. Apart from that, Yashmin, anything else and any closing words from you?
Any closing words? Just I wouldn't want to do what you're doing as property managers. So yeah, hats off to you. You do amazing jobs under very difficult circumstances. I wouldn't. Do you know what actually frightens me? I mean, my inbox is bad, but I don't know what your inboxes are like because I can imagine there's like thousands and thousands of
You're
emails.
most welcome to spend a day with me in the office.
I think I'll pass on that. But I just don't know how you would keep on top of it. So yeah,
Some
hats off
days I
to
don't know
property
too. It's been great having you.
Thank you
Thank you
so
so
much for
much.
inviting